All rise. Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court. Now sitting.
Please be seated. Good morning and welcome to Kansas Supreme Court. I think that it looks like all of those who are in the courtroom today probably don't need an explanation about our court processes, but we may have people on line watching our live stream. So I would like to explain that the court has had briefing from parties that we have read, and we've also looked at various other documents to help us prepare for today's hearings. We are looking forward to the arguments from the attorneys to help us understand the situation and to give us an opportunity to ask questions of them about their arguments. As we do so, we will often be looking at our computers or our notes as we look for different things that we have focused on in our preparation. So when we do that, I just want to assure everyone that we are still active listeners and focus on what the attorneys are saying and the exchange with the court. We just do these things to help us understand and assimilate information. With that, I will ask Mr. Doug Shima, the clerk of the Kansas Appellate Courts, to please call the 9 a.m. docket.
First case on the 9 a.m. docket for Friday, February 2nd, 2024 is appeal number 125430. State of Kansas versus Jalen LaRon Johnson, Leavenworth County. Briefs both sides.
May it please the court, Corey Call, appellate defender, representing Mr. Johnson, present and ready for argument. Your Honor, may I reserve 3 minutes for my rebuttal?
3 minutes is granted.
Thank you very much.
May it please the court, Ethan Zipsigler on behalf of the state of Kansas, present and ready for argument.
Second case is appeal number 126016. State of Kansas versus Desmond C. Peters, Sedgwick County. Briefs both sides.
May it please the court, Sam Shire of the Kansas Appellate Defender Office appearing on behalf of the defendant appellant Desmond Peters, present and ready for argument. Your Honor, may I please reserve 3 minutes of rebuttal argument?
3 minutes is reserved.
Thank you, Your Honor.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present and ready for argument.
Your Honor, that concludes our 9 a.m. docket.
Thank you. Thank you, counsel. At this time, I will call 125430, State of Kansas versus Jalen LaRon Johnson.
May it please the court, Corey Call, appellate defender, representing Mr. Johnson. This case, you may remember, involved some teenagers from Missouri who arranged a deal to sell a gun. Some teenagers from Gwinnett County, they met in Leavenworth County. Actually, the Missouri people brought a BB gun to the sale, and then the transaction occurred. And as the kid who was walking away from the car realized it, the car started to pull away, and Mr. Johnson testified he saw a gun, and that the driver had a gun, and so he shot at the car, killing a 12-year-old in the back seat. This case is a bit unusual in that this entire transaction occurred in the parking lot of a pharmacy, which had a security camera focused on the parking lot. So we have this entire, in the record is a video of the entire transaction, which we're able to see, the jury was able to see, and we're able to see exactly what happened. We raised several issues in the brief, the first of which was procedural error, and we raised several issues of procedural error. One of those was that in closing argument, the prosecutor was talking about self-defense. And there was a section where sort of bookended informed the jury that BH, who was the person who was killed, it wasn't his fault. He wasn't a danger to Jalen. The comments started with, it's not BH's fault that he was shot in the back and killed. Jalen Johnson pulled the trigger, killing Brian, not caring who it may have hit. It was reckless, should not have had the gun in the first place. Then they describes the subjective and objective components of self-defense. And no evidence anybody was waving guns around. Surely no evidence that BH on the back passenger side was doing anything. Now, of course, it's irrelevant whether BH was violent or not. The anticipate he saw the driver with a gun. That was the danger that he saw. And if the jury believed that the driver had a gun and it was reasonable for Jalen to respond to that, then it's irrelevant whether BH had anything back. The difficulty with this is that there's some intuitive sense to this. The idea that if you harm somebody in self-defense, that person has to be the individual who you feel threatened by. But that's not the case. And so if you look at as far as the harm on this particular error goes, in Ward, referring back to Kleypas, this court talked about, did the error affect the verdict? And certainly we talked about the evidence, we compared the evidence, was the evidence overwhelming? But it's, as this court well knows, it's not a situation where would a hypothetical jury on these same facts in a trial without this error return the same verdict? The question is, did this error in this trial affect this jury's verdict? And that's interesting here because the question here was, and the dispute at trial was, did Jalen see a gun? The state presented evidence that the windows were tinted, that it was driving away, that he may not have been looking at the car before the trigger. The defense presented evidence that he said, I saw there was a gun. There was a gun in the car. If you watch the video, it appears that the car is still turning. So there's all this conflicting evidence. But if the jury accepted the state's invitation, accepted the state's argument that, well, BH didn't have anything to do with this, then it would be able to ignore all of that sticky deciding of who's credible, who's not credible, what happened, the evidence, because it was undisputed.
It seemed to me that the argument, he's reciting all the facts surrounding the circumstance, and viewed in context, it seems to me that the prosecutor's really just suggesting this is evidence would be more likely to support the felony murder, which was the underlying felony was a reckless offense. So the conduct was reckless as opposed to self-defense.
Sure, but whether or not BH was a threat, whether or not BH did anything to cause Jalen to act wasn't relevant based on this evidence to the point of whether it was reckless. If the driver had a gun and Jalen saw the gun and he reasonably believed that his cousin was in danger, then regardless of whether that BH in the back seat wasn't doing anything, it would not be reckless to shoot at the car under those. And there were other facts that they talked about. But as far as this argument, again, it's a 2-paragraph argument bookended by the fact that BH, it wasn't his fault. He didn't do anything.
But what were the jury instructions? Did the jury instructions say that, did the jury instructions clarify that issue? That self-defense, when self-defense would apply?
I believe what the jury instructions certainly did not reference BH.
Right.
But I don't think they referenced the driver. They said, was he in fear? And so, given the prosecutor's argument, I think a jury, certainly it'd be difficult for the state to prove beyond a reasonable doubt that the jury did not think that fear, was he reasonable fear of his life related to any fear, but in the state, it wasn't BH's fault, related specifically to that fear.
But the defendant testified why he was in fear, correct?
That is correct. That is correct.
I mean, are you saying the jury wouldn't understand that?
I'm saying that it may make sense to the jury that if, that the person that that you may be in fear of that person, but you have to be, that in order to claim self-defense for harming a person, that you have to be in fear, threat of that person.
Okay, so what you're saying is that the defendant gets up and testifies and says, I saw a gun, and so I was in fear that my cousin was gonna die, and so I shot. And then in closing argument, this statement is made about BH didn't have a gun, he didn't do anything. And then the jury instruction is given that said, if you believe that he was in fear of his cousin, not specifically with the names, but a third party, and that the jury is going to think, oh, I think this jury instruction means that if he was in fear of BH was gonna kill his cousin, you think the jury would think that? Is that reasonable to think?
I think, given the state's comment, that I don't know how you interpret the state's comment as arguing anything but that.
But the sentence before is no evidence anybody was waving guns around. So doesn't that imply that he really is looking at the entire scene and really focusing the jury on that as well? I mean, would it have made a difference if he had said the driver didn't have a gun, the front seat passenger didn't have a gun, H didn't have a gun? But why would that kind of iteration be necessary when it's prefaced by no evidence anyone was waving a gun?
Well, I think it's the difference is, in this case, the state focused the invitation, the one individual they talked about, I don't believe it was even the driver, but the one individual they talked about was the person who was harmed. And I think it would have made a difference if they'd gone through each individual person, then it wouldn't have specified the person who was harmed, which I think, I think it's reasonable that it's not going to be the driver and it's not going to be the other person who wasn't harmed and who nobody said had a gun. I think that's the jury would understand that. But if you're talking about the person who was harmed, it wasn't his fault that he was shot, that a jury could understand that to mean that he has to be the one who was at fault. I think that's the very purpose of the statement.
So for purposes of my question, let's assume you've convinced us that your interpretation of the prosecutor's argument is correct. In other words, the prosecutor was saying exactly what you're saying was said. How does our decision in the Betts case impact your argument, which was the Wichita shooting by a police officer, where the Wichita officer attempted to use self-defense against a dog and struck an innocent bystander? And our holding essentially was, I think, even when defense of self is legally justified, that does not absolve one of reckless conduct in the exercise of that lawful defense that injures a third party.
Sure, and I think that the key to that was BH a third party? I think the question is, I don't think this court.
I'm sorry to
No, go
interrupt,
ahead.
but
No, please.
just to clarify the question I'm trying to ask, why can't a prosecutor argue, based on the existing state of the law, that even if the defendant was justified in the use of force, that justification cannot absolve him of the crime charged, which is reckless injury to the person in the backseat? And that seems like consistent with what you're saying the prosecutor was actually arguing.
Sure, but that is only true, if I understand your question, that the state of the law would only apply to BH if he was an innocent bystander, as opposed to a co-conspirator, as opposed to a cohort, as opposed to someone who was involved in the criminal activity with the person who had the gun, the danger.
Couldn't the jury have drawn that inference from the evidence?
Especially since he was 12 years old and,
And that's the exact argument the prosecutor's making. He wasn't involved. That is the argument,
right.
as you've characterized it.
Right, but I understand that, but I don't think that is a reasonable argument under Betts that, sure, he's 12 years old, but he is in the car and he is involved in the conspiracy, in the crime. if he could have been, I don't know if a 12-year-old can be charged with aiding and abetting, but he could have been charged with aiding and abetting in the theft or the robbery or whatever happened in the crime. He was a participant of the crime by being in the car. There's no shortage of cases that, I mean, I don't think this court would hold that four guys in a car go do a drive-by shooting and only the shooter is responsible. You're in the car, you're culpable for that, absent some other circumstances. The second statement by the prosecutor, so when Jalen was talking to the police, he had said that, or I guess during his, the police officer told him that they killed a 12-year-old girl, and Jalen has a little girl. So he said he thought of his little girl, and the prosecutor then, in closing, stated that asked the jury, was he thinking about his daughter when he was holding a Glock 45 to watch over a gun deal? Was he thinking about his daughter when he shot 12 rounds? Was he thinking about his daughter when he went back to house and did some cocaine? Was he thinking about his daughter when he told multiple versions of what happened? Was he thinking about his daughter when he killed BH? And yeah, the question here for the jury was, I mean, it was what he was thinking at the time, but it had nothing to do with his daughter. These statements were designed solely to inflame the passions of the jury and for them to decide that
Yes.
not credible.
Sorry, I didn't mean to interrupt you.
no.
I have a question about that argument. Okay, so he did testify that he was thinking of his daughter right before he went into the interviews with the detective. That was his direct exam. On cross, the state asked those very questions that you're identifying as that were repeated in closing argument. So essentially, it looks to me from the record, the prosecutor simply restated the very cross-examination questions that were presented to Mr. Johnson. And those questions and the testimony elicited were not objected to. And it almost seems to me that when we frame, all the prosecutor does in closing is simply repeat the questions that were asked on cross. It almost seems to me like framing it as prosecutorial error at that point circumvents 6404's contemporaneous objection rule. What do you think about that? Because there's no argument saying that, oh, and that you can clearly see he's a bad father. It just simply seems to me a rehash of the evidence that went down on direct and cross.
Well, I think it is erroneous both times. It wasn't objected to, so therefore the issue isn't preserved, and by statute we can't raise it. It doesn't change the prejudicial effect or the error that occurred. It's just a procedural hurdle that we have on appeal. And the prosecutor is still bound not to try and inflame the passions of the jury. The fact that they did so without objection, and therefore we can't raise that as an issue in the fairness of the trial doesn't change the unfairness of doing it in closing argument.
But like in State v. Lowry and other decisions, we've said when the essence of the objection is really evidentiary, you can't reframe that as prosecutorial error because of the legislative mandate in 6404. I just didn't know if there's a way to distinguish those cases here, or
I think if
I'm sorry, I didn't mean to continue us for too long here. That'll be my last question.
Oh, that's a good time. I think the difference is in those cases where you're talking about an evidentiary, I think they came up in terms of Doyle. This isn't purely an evidentiary issue. In other words, so it's prosecutorial misconduct for because I think in those cases it's prosecutorial error for a prosecutor to introduce evidence which is inadmissible, and then they talked about that inadmissibility in there, as opposed to something which is really a closing argument. There's an independent basis of the prosecutor's error inflame the passions of the jury, which prosecutors are not allowed to do in any case. I think it's a difference between is this could you have raised, is it independently raisable as prosecutorial error on its own if the evidentiary hadn't happened? And I think in this case, it would be. Thank you, Your Honor.
Please, the court. On the question of prosecutorial error, the real question on the issue of whether BH had a gun, to me, is whether or not the prosecutor misstated the law. And there is just no possibility he did. Within the context of the closing argument, he addresses centrally the question of, did Lloyd, the driver of the car, have a gun? Which is no. But then he's entitled to go through everyone in the car because the law says if Mr. Johnson is afraid for his life, reasonably and actually, he can use deadly force, which means to anyone in the car. The prosecutor is entitled to make the arguments relevant to the case, to argue his case. And that can't be limited because the defense is like, well, we didn't really argue that position. Prosecutor is entitled to argue anything that is reasonable within the context of the case, which is, did anyone in the car pose a danger to Mr. Johnson? And the prosecutor's answer is no, and the jury's answer was also no. So there's just no real argument that the prosecutor misstated either the law or the facts of the case in the closing with relation to the statements about BH. Similarly, the questions about thinking about the daughter, in addition to the fact that, again, these are, as Justice Wall said, attempts to make an evidentiary issue a prosecutorial misconduct or prosecutorial error issue. There's the fact that Mr. Johnson's credibility is at issue in this case. He changed his story multiple times, and one of his things that he testified as to why he lied to the police was because, well, I was thinking about my daughter. He's put that in front of the jury, so the prosecutor is entitled to respond to it. Do you think he was thinking about his daughter when he was doing these things? Do you think that's the reason he is motivated in this case? Do you think that's his motivation for changing his story? Or do you think it's because he doesn't want to get in trouble? Do you think the claim of self-defense at this late hour, after he's claimed multiple different reasons why he said he needed to use self-defense, multiple reasons why he fired the gun, do you think it's really that he walked in there and he was thinking about his daughter and, oh no, I need to change my story now? So I think it's relevant. It is a commentary on the evidence.
Does it matter though that that temporarily that he wasn't, the first time he mentioned that he was thinking about his daughter was in response to the detective saying that a young girl was killed in the incident. In other words, then what is the relevance of any reference to thinking about his daughter before that disclosure is made?
The relevance is his state of mind is an issue before the jury. So calling into question the things he's said about what his state of mind was in this case is going to be relevant. As to the other issue of prosecutorial error, we do concede that it was error to ask the jury in voir dire if they could do their job. There is a United States Supreme Court decision on this that says do not use that language. So obviously the second thing we turn to is this error harmless? And I think beyond a reasonable doubt, this error has to be harmless. First of all, it is very close to language that the prosecutor could have asked. The prosecutor asked, do you understand your oath that you're taking in this case? They could have asked, are you comfortable convicting if you believe beyond a reasonable doubt? And all of those, the variances of those languages are so small that to believe that it could have had any impact that at one time he made an incorrect statement is not reasonable. And then further, the evidence in this case is just simply completely overwhelming. Regardless of what Mr. Johnson said, the video speaks for itself. He is not looking at the car when he makes the decision to fire the gun. He is looking at his cousin. You can watch it. He is looking at his cousin and he immediately raises the firearm and starts firing at the car. It is simply impossible that he saw a firearm in the car. The video speaks for itself. And all of the surrounding evidence speaks for itself. And the fact that his cousin didn't see a gun when his cousin was sitting next to the car. And the fact that his cousin says the reason he fired is because he said, they ripped me off. And the other person in the car said, they have my money, shoot. Which is also what Mr. Johnson initially told police. He said the driver of his car told him to shoot and he shot. And then later he claimed self-defense. So all of this is to say that any error on behalf of the prosecutor in closing or voir dire would have had absolutely no impact on the jury. They deliberated for less than an hour in this case. They did not have any questions. They came back with a decisive verdict, and the evidence in this case, they could see for themselves. There isn't a conflict. There is no real conflict as to the evidence. The only created conflict is what Mr. Johnson testified to, and that is not believable. He changed his story versus everyone else who had testified consistently, and so any error is beyond a reasonable doubt harmless. If there are no other questions, I think the other issues are, I'm comfortable with the briefing on them. The issue of whether it was improper to impeach him on discovery. I don't think there's any case law to suggest that impeaching a witness based on the fact that they've seen other discovery or seen other witnesses is improper. And so I don't believe that there's any real issue there.
Thank you.
Thank you, Your Honor.
3 minutes. Thank you, Mr. Cole. I call 126016, State of Kansas versus Peters.
May it please the court, Sam Shire, the Kansas Appellate Defender Office, appearing on behalf of the defendant appellant Desmond Peters. This is a direct appeal from a felony murder prosecution that resulted in multiple convictions. My client is currently serving what I would view to be the functional equivalent of a life without the possibility of parole sentence. In our brief, we raised 8 issues. At argument today, I want to focus on issue 1 in the brief. That would be the ineffective assistance of counsel claim. So issue 1, the IAC claim, is raised in a motion for new trial, developed through an evidentiary hearing. And the gist of the claim is that trial counsel performed deficiently by inadequately impeaching the testimony of the state's 2 most important witnesses, Trey and Trey's grandmother, Mrs. Brooks. To set the stage for talking about this issue, I want to note something very unusual about this case, and that is the extent to which the prosecution was reliant upon uncorroborated accomplice testimony. This is a case that arises out of a home invasion gone wrong. There's evidence that several perpetrators entered a home. During the home invasion, a victim was shot and killed. One of the surviving victims was able to identify 2 of the perpetrators. One of those perpetrators is Trey. None of the surviving victims identified my client as being at the crime scene. And there's also no forensic evidence that places my client at the crime scene. There's no DNA, fingerprints, GPS, anything like that. Literally, the only evidence in this case that puts my client at the scene of the crime is the testimony of an accomplice, Trey. Now, Trey's testimony is to a limited extent corroborated by his grandmother. That would be Mrs. Brooks. Mrs. Brooks says that she saw my client with her grandson approximately 30 minutes before the homicide would have occurred. So Mrs. Brooks's testimony is important too, but I don't think that I am exaggerating at all to say that the state would have no case to prosecute had Trey, not accused my client of being his accomplice. So having said that, turning to the IAC claim, I think given that evidence, it's obviously very important for trial counsel in this case to impeach the testimony of Trey and Mrs. Brooks. And he performed efficiently by leaving very significant impeachment evidence on the table and unused. Trial counsel could have, but did not, admit Trey's prior statements to law enforcement after Trey had entered into a plea agreement with the state.
Isn't this a trial strategy, though, as I understood the evidentiary record, that first of all, she's a sympathetic witness, so strategically didn't want to, garner even further sympathy through an aggressive cross-examination. And in addition to that, really wanted to focus, develop an alibi defense and didn't want to emphasize her testimony throughout cross-examination, which would have undermined that alibi defense. Why doesn't that fall in the bucket of trial strategy?
Well, Your Honor, number one, with respect to Trey, not Mrs. Brooks, but Trey, the trial court never explicitly accepted the testimony that this was strategy not to impeach Trey. The trial counsel's rationale for why there was no ineffectiveness with respect to Trey was that trial counsel sufficiently did the job with his limited impeachment. And I think it's important to note that the trial court actually didn't take everything trial counsel testified to at face value. Trial counsel testified that he had no idea whether a particular witness, Mrs. Kinsey, was going to offer favorable testimony to the defense or not. And the district court at the evidentiary hearing flatly rejected that contention. The district court made it very clear that everyone, including defense counsel, knew exactly how Ms. Kinsey was going to testify prior to trial. So there's that. I'm not sure that Trey's testimony was found to be strategic, or excuse me, the limited cross-examination of Trey was found to be strategic. But even if we are dealing with trial strategy here, this court has noted in the past that an attorney's mere invocation of the word strategy does not insulate his or her performance from constitutional scrutiny.
But Mr. Shire, I mean, I think just from what Justice Wall said, what do you do with a client that says, I wasn't there, and insists that that's what the defense should be, I wasn't there? And so if that's this, that's what you have your client saying. And so now post hoc, after there's a conviction, to say, you should have done more to talk about, when I was there. I mean, how is that compatible?
Two responses, Your Honor. Number one, the client doesn't determine what trial strategy is. That's the attorney's job. It's the attorney's job to come up with an effective trial strategy. Number two, these are not mutually exclusive things that could have been done at trial. If we were to assume that there was alibi testimony coming from Ms. Kinsey, even if one were to assume that that testimony was forthcoming, there's no reason why you don't adequately impeach the state's witnesses. This is not an either-or decision. Competent attorney would do both: present the alibi evidence and, in addition, impeach the testimony of the eyewitnesses.
Let's talk about that impeachment. The trial lawyer said he was aware of Moore's previous statement and used them to prepare for trial. He did question Moore about the failure to name Peters as an accomplice during the first interview. He got Moore to concede that his story changed by the next interview, in part based on his understanding of the charges that were now being lodged against Moore and the penalties that Moore was now facing. And he questioned Moore about the selective memory. And then he said, with regard to the alibi defense, that he didn't want to identify all this, he didn't want to emphasize Moore's identification of Peters, Rather than focusing on the line-by-line inconsistency with the prior statements, his strategy was to attack Moore's character. He focused on the plea agreement that Moore signed and tried to bring that out, that he was a liar and a thug. And he was the one that probably pulled the trigger. I could go on and on. I mean, all of that was presented at the motion for new trial.
That was the testimony, yes. And particularly, trial counsel's strategy with respect to Trey is to show, in his words, quote, that Trey is a liar and a thug and probably the one who pulled the trigger.
Right.
And that to me begs the question, Your Honor, why do you not put on evidence of Trey's demonstrable lies? After Trey entered into a plea agreement in this case, he claimed he had no idea who my client was. He had to pick him out of a photo lineup because this is a near stranger. That is demonstrably a lie if you look at the trial evidence. My client was best friends with Trey's brother. He was a family
All that came
friend.
out.
That did not come out, Your Honor.
But the grandma testified to that.
The
The grandma testified that the defendant, he was out on the porch because he was really good friends with the brother that died.
Exactly, Your Honor. That would have been clear. What wasn't brought out at trial is the fact that Trey had made this inconsistent statement that he had no idea who my client was.
It was brought out.
No, Your Honor, Trey's statement was not brought out at trial.
That he said he didn't know who he was?
That's exactly right, Your Honor.
Okay.
Also not brought out at trial, Trey claimed that there were 5 accomplices at one point when he's talking to law enforcement, as opposed to the 3 he named at trial, not brought to the attention of the jury. I think this is particularly important because it shows that while Trey is making up this story based on what he hopes people will believe, he's more than willing to throw innocent people under the bus. 5 versus 3 is a pretty big inconsistency. It should have been brought to the jury's attention.
But when you look at those isolated, okay, 5 versus 3, but I think, are you talking about 5 total versus 3 total or 5 total versus 4 total?
5 total accomplices making 6 versus
Okay.
3 total accomplices making a total of 4.
Okay, so 6 versus 4, and then this issue of that should have been brought out, that he said he didn't know who the defendant was, okay? And that when you take all these little line by line inconsistencies, as trial counsel said during the motion for new trial, and you point out that trial counsel brought up Moore's plea agreement, that the state had dismissed the murder charge. He was prosecuted as a juvenile for a single charge of aggravated robbery. By the time he testified, he had already completed his whole sentence, and he was able to walk away. All of that and all the things that I already brought up, you're saying that this would have resulted in a different outcome?
There is certainly a reasonable probability, Your Honor. Absolutely. It would have shown that Trey had lied in the past under oath and to law enforcement after he entered into a plea agreement. And I just want to carry on, and I want to touch on Mrs. Brooks, obviously, too, because that's obviously very important. And what I want to note with Mrs. Brooks is if you look at her trial testimony, she makes a purely visual identification of my client. She is standing inside her house. My client is supposedly standing on her porch. A door is open and she sees my client. Purely visible identification. Trial counsel could have, but did not, use statements that she made to law enforcement that she was in the middle of a diabetic episode at the time when she would have made this purported
But at the motion for
identification.
new trial, she said, because what happened at the motion for new trial, something about the color of her outfit, color of somebody's outfit. But at the motion for new trial hearing, she denied that she had a diabetic attack that affected her vision at all. She just needed to take her meds, and the only problem she had was with her vision at night. So that's what she testified to at the motion for new trial. Why would we have expected anything different had they asked her about that at trial?
Your Honor, I suspect she would have testified similarly at trial as she did at the ineffective assistance of counsel hearing. The issue is with the failure to present the statement that she made to law enforcement immediately following her son's arrest. immediately following her son's arrest, she unequivocally says, I am in the middle of a diabetic episode at this time. It began at 7 o'clock.
But
She
she
has
said in
asked,
the motion for new trial that I had a diabetic attack, but it did not affect my vision.
Your Honor,
That's
I-
what she testified to at the motion for new trial.
I believe that the jury would find it more credible, the statement that she made to law enforcement immediately following her son's event, than the testimony that she would give 4 years
That
after
would
the
have changed the
fact.
outcome of trial?
Absolutely, it would. This is a purely visual identification. Trial counsel did not highlight the fact that this is a witness who had difficulty seeing in the best of circumstances. At the trial, she attempted to, well, she did identify my client from the witness stand, from the defense table, and said, I can barely see that far. I can't really tell what color shirt he's wearing.
But she
The-
couldn't see what color it was.
Exactly, Your Honor. And she also said, I can barely see that far. Now, we know from evidence, from testimony she gave at a trial just a month later, that if she would have been pressed on the matter, she would have admitted that her vision is kind of going. This is a witness who cannot see in the best of times, and based on her statements to law enforcement right after her son was arrested, she is in the middle of a diabetic attack while she's purportedly making these observations. This is unreliable testimony, and that didn't get across to the jury. And for that reason, I would respectfully ask this court to reverse my client's convictions and remand this case for a new trial.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. I'll focus on issue 1 briefly, since that's the only issue that my friend on the other side has addressed today. I think that when this court looks at these issues, that there is a common theme running through the 3 claims that were made. First of all, this is a distilled version of a throw claims at the wall, scattered after the fact, post hoc reweighing that began with defendant and then was attempted to be enhanced by a subsequent attorney. And we've distilled it down to these 3. And these 3 are apparently the best claims that the defendant has. And what those claims have in common is that, well, the trial attorney, he actually performed in all 3 scenarios. And he actually did a pretty good job. But maybe an attorney, from the perspective of the defendant, might have done one more thing here or there, and that maybe that would have changed the outcome of this case. That is not the standard for either constitutionally deficient performance, nor is it the standard for reversible prejudice in this case. I'll address the two points that were argued here briefly and leave it up to the court for any specific questions that you have. Regarding the impeaching Trey with his statements, I think there was the other thing that was notable is that what we have is a characterization of statements that were made, arguments about how a jury might have considered something. Again, that is not the standard for constitutionally deficient performance. Trial counsel had Trey's prior statements to law enforcement. He reviewed them before proceeding to trial. As Justice Wall pointed out, he testified explicitly at the motion for new trial that it was his strategy to not nitpick with these transcripts. He didn't think it was even necessary to try to point the finger at Trey as some kind of ringleader. He was a thug. Trial counsel actually also testified very clearly, and I think that even opposing counsel would have to acknowledge this, that while nitpicking a witness with minor inconsistencies is one way to conduct an impeachment, it is boring, it can be counterproductive with juries, and can even allow the state to rehabilitate and demonstrate over and over all of the prior statements which are more likely, more important to juries. That truth is borne out here. In this case, what we had was an initial statement the morning after the murder. Trey, in that statement, admitted that he was there to do an aggravated robbery. He admitted that there were others with him. He just wouldn't tell anybody who they were. Didn't want to drag anybody else's name into it. Roughly a year later, after he is appointed counsel, he offers a second interview to law enforcement. Candidly, it does start off a little choppy. He says a few things here and there that are inconsistent about how well he may have known this unknown person, whether it may have been a cousin to one of the other people involved. But at the end of that interrogation, he settles on what his version of events would be from that point forward. And that was consistent with his trial testimony, that it was the defendant that went along with the other three that went over there to do this robbery. He was involved from the get-go and throughout.
Was that his statement before the deal was made?
I don't know that it's entirely clear that one way or the other, but what I would say is that it was clear that whatever the deal was, it was revocable. If the state felt that Trey was, I guess, going too far off into the weeds is the only way I can say it. Like if he was testifying in a manner that would be completely inconsistent with his prior statements. So I think there's actually very little inconsistency that could have been fleshed out here. I would also note that to say that Trey is completely uncorroborated is, again, a mischaracterization of the record, frankly. He's corroborated by Carol Brooks, as my opposing counsel noted immediately after saying it was uncorroborated. He's also corroborated by the forensic evidence regarding the guns that were used. Trey's gun that he testified was not used. It was found with him at the time of arrest. It didn't match any of the shell casings or bullets that were recovered from the scene. One of the other individuals who had a .40 caliber, that gun was not found, but there was a .40 caliber casing at the scene. Scott Yarborough, Lescotric Yarborough's 9mm was never found. There was a 9mm casing at the front door of the home. The defendant's .45 caliber. The forensic evidence from the autopsy was consistent with exactly how Trey said the defendant shot the victim in this case. That gun that Trey testified was given to Scott to dispose of. It's later found at Scott's girlfriend's house. There is consistency with Trey's statements.
Wait, who's Scott?
Lescotric Yarborough.
Oh, okay.
If there are no other questions, again, I think it is clear that this choice of impeachment was strategic. It was completely reasonable. And I would just simply remind this court that the standard, when we're talking about strategy, is the defendant would have to demonstrate that no competent attorney would have adopted the strategy that was used here in order to fall below the constitutionally deficient standard. It doesn't even come close.
I've got a few minutes left. Let me shift to another question I
Sure.
had, and that's on the Batson question.
Sure.
One of the, it's always troubling to me as to how creative state can get in its race neutral justifications. And this one kind of stretched it to the limit for me. One of the race neutral reasons given was that one of the jurors responded to the question of what happens if I don't prove my case beyond a reasonable doubt. And the juror responded that I would find them innocent. And the prosecutor's race neutral reason was, well, he didn't say not guilty. So I thought he was more sympathetic to the defense. And it just seems to me that the colloquial that we use, presumption of innocence, we don't say not guilty until proven guilty. We say innocent until proven guilty. What's wrong with that explanation? And isn't that just, to me, that stretches
Okay.
the whole race neutral notion. It just seems pretextual to me. What do we do with that? Or what do I do with that concern?
I think that the first place that this court should start is with the first step here, because it was controverted whether or not there was even a prima facie showing that that strike was improper. I think if you look at the defendant's objection at record volume 21, page 278, it's speculative. completely speculative. And then we'd start to talk about the race neutral reasons. And
Wait,
I know
wait,
you're
wait,
talking about.
Back up, what's speculative? State strikes the juror. Counsel makes an objection and a race neutral reason must be provided to the court. And that's the explanation. Isn't that what happened?
That's what happened. I would say that moving on to the second and third steps of Batson, they aren't always necessary, but but case law tells us that district courts should conduct that analysis. And what we had here was a defense objection, was that they didn't see a reason why there should have been strikes. Probably one of, I believe, 4 African-American jurors on the panel, and said that there's nothing to indicate other than she would be fair and impartial. The prosecutor gave 2 reasons why he felt that 2 race neutral reasons that striking her was justified. One, she did come back late. And I grant you, how late is a
Yeah, I was
question.
wondering about that too.
And I understand.
30 seconds late.
And we know she came back late, and I would suggest that the other consideration there is that the court ordered a 5 to 10 minute break. We don't know when everybody else got back. Did they come back after 2 or 3 minutes and then she's not back till after 11? It's a race neutral reason. And as to that point, as to Your Honor's question directly regarding her saying innocent, it reflects that she doesn't understand what's going on here.
How
Because-
is that?
Because the state asked if.
Render a verdict for I don't prove my case, and what's gonna be the verdict, and she says innocent? Anyway. So
The first time,
you're.
the first time.
Go ahead,
I
explain.
might agree with Your Honor, but when you look at this record, she's pressed by defense counsel to try to get her to say the right thing, which is not guilty. Twice, she's pressed on that. Twice, she insists she's going to say innocent. That's not the same as not guilty. It's not. And that is a race neutral reason. You know, in the previous cases, I couldn't help but note.
The race neutral reason is she doesn't get the distinction between not guilty and innocent. That's the race neutral reason.
I think that is a race neutral reason. I think that is fair, that it indicates that she may well hold the state to some kind of higher bar in her mind, that the presumption of innocence is something that is nearly insurmountable. And I think that is a
Well, I
fair
think
race
what the
neutral-
prosecutor said was, I felt like she would be overly sympathetic to the defense.
Correct.
So it wasn't like it was just,
He continued, that continues at record volume 21, page 279. Not only is she overly sympathetic, she would be overly examining the evidence, not just to go with the legal burden, but with her own personal belief that it was innocence, that the reasonable doubt bar is higher. And I think that is a race neutral reason.
I'm afraid my notes may be wrong, so let me. Okay, so we got 2 jurors. RH is the one that showed up late.
No, that's JH.
JH, I didn't have my glasses on, sorry. And then I got RH, so I just want you to focus on RH.
Okay.
I'm willing to give you the show up late and all that. I can understand that, but I think going to Justice Rosen's point, RH stands out more as, I'm not willing to assume she doesn't have a bias, was the quote that I wrote down from the prosecutor. And that does seem a little thin.
So I think I'll talk.
So help me, just give me the race neutral reasons why RH gets knocked off the jury.
I would direct the court to its record volume 21, page 284. The prosecutor, he was willing to acknowledge that there was misunderstanding, and I'll address what that purported misunderstanding might have been, but he refused to, he was not willing to assume that RH is jumping to not guilty just because a defendant doesn't testify or the defense does not present evidence. Doesn't indicate a bias or expectation that he's going to vote guilty no matter what. That was what RH was asked about. If the defendant doesn't testify, he's going to vote not guilty. If the defendant presents no evidence, he's going to vote not guilty. I don't view that. I don't know how one could view that any differently other than this is an individual who doesn't get what's going on and he is going to vote not guilty.
so was the question, is defendant guilty if no witnesses, if he doesn't present any witnesses?
It was, quote, if a defendant doesn't put on any witnesses, does that mean they're guilty? And RH replied, not guilty.
And then the next question was, is defendant guilty if he doesn't testify?
Whether that means they're guilty, and he again said, not
Not
guilty.
guilty.
Yeah,
Right.
it's confusing. It's indicative of someone that's not tracking what's going on and is inclined to vote not guilty no matter what. It's certainly a race neutral reason, and it is certainly also supported by the record.
Not guilty is not another way to say no in that context. And are they guilty? Yes, you know, you're looking for the yes or no, but he's like, not guilty.
I think, I don't know that you can I don't know that I would say that this is necessarily even fishing for a yes or no. It's trying to determine whether or not RH understands this process. If a defendant doesn't put on any evidence, does that mean they're guilty? But that doesn't it doesn't even necessarily make sense. And it clearly is something that RH didn't catch and wasn't willing to try to address any further than just saying not guilty. If a defendant doesn't testify, well, they're not required to testify. The defense is not required to do anything. So to have someone that's just automatically jumping to not guilty when posed with these questions, it is concerning. I will circle back just briefly with my last 39 seconds here. Regarding Carol Brooks, again, what we have here, the attack about her visual acuity and her diabetic situation is absolutely not as clear as my opposing counsel would like to paint this. Trial counsel again indicated this was clearly a choice of strategy. I would note that he also mentioned as much during his closing argument, in addition to his testimony at the motion for a new trial. Need to look no further than Ms. Brooks' testimony at the motion for new trial to see that trial counsel made the right choice here. She's fiery, clear-minded, consistent, didn't embellish anything, even for her own grandson, Trey. So my time just expired. If there are no other specific questions from this court, I would submit the remainder of the issues on the brief with one final note. I would say, I believe it was issues 5 and 8. The state did agree in our brief on issue 5 that reversal of that possession of a firearm charge is proper. I would just ask that that be reversed and that vacating that sentence, it be all that occurs, because as long as there's at least one other conviction that stands here, that's never going to be the primary count. There's no need to have a resentencing. So we asked for a remand for a nunc-pro-tunc on those two very narrow. Thank you, Your Honors.
May it please the court. I'd like to come back to trial strategy as it relates to Mrs. Brooks. And I think what I want to note here is that the trial strategy that was testified to and accepted by the trial court was that, yes, there is impeachment test evidence that could have been used against Mrs. Brooks, but that it was reasonable not to bring that out at trial because she was an obviously sympathetic witness in the sense that she had obvious health problems at the time she was testifying. So essentially, the trial strategy is that I am not going to admit this exculpatory evidence because to do so, I would have to confront a sick witness. And I want to note that there's an obvious problem with this strategy, and that is the confrontation here, or the impeachment, does not have to be direct. Mrs. Brooks is testifying at trial. She is an available witness. Her prior statements are not hearsay. They can come in. The detective who heard her statements testified at trial. So even if it was sound strategy not to impeach Mrs. Brooks on cross-examination, there was no reason not to bring in through other means evidence that she was having a diabetic attack at the time that she purportedly saw my client. There's just no rational reason not not to do that impeachment, given that this is a purely visual identification.
But what if he had pushed and said, look, Mrs. Brooks, you were in the middle of a diabetic attack and you couldn't see very well. Isn't that true? Then what if she had said, well, I was having some problems, but I knew him. I know that guy and I heard him. I saw enough of him to know someone that I've seen many times. I mean, isn't that the risk that counsel has to consider when he decides to sit down rather than ask another question?
Well, Your Honor, two responses. Number one, that worst case scenario that you're outlining is basically what happened. Mrs. Brooks said with no ambiguity or uncertainty that she saw my client. So there's no reason not to put on evidence that she has difficulty seeing and was in the middle of a diabetic attack. The other thing that I think is important, I am not faulting defense counsel for not eliciting favorable testimony from Mrs. Brooks. Mrs. Brooks may not have testified as the defense would have liked. What can't be changed is what she said to law enforcement immediately after her son was arrested. That's locked in stone. That statement is not changing, and that statement is incredibly exculpatory.
But don't you have to consider that if he had asked about that, she would have been able to explain it away, and by explaining it away, there would have been an emphasis on her certainty of who it was. I mean, isn't that really a trial strategy decision?
Your Honor, to the extent that was trial strategy, that wasn't articulated by defense counsel. To the extent that that could be trial strategy, I believe it would be an objectively unreasonable one. We have a visual identification. I can think of absolutely no better way to challenge a visual identification than by showing to the jury that the witness has poor eyesight in the best of circumstances. And according to her own words, she was having a diabetic episode at the time. That obviously also would have affected her perception, I think a reasonable juror would think. Having said that, I will conclude my rebuttal argument at this time unless this court has any further questions. Thank you, Your Honors.
Thank you to both counsel for your arguments in this matter. The court will take this appeal under advisement. We are now in recess until 10:30.